Everyone. Good evening. How are you doing? So, my name is Ifama Odolami, immigration attorney from the Odolami Law Firm, and it is Tuesday, and I decided to do this live because I want to clear up a couple of. I've been getting a lot of questions, and I just want to answer some of those questions for you guys, so that you know the answers to it. You don't have to book a consultation to answer one question. So I will take questions when I'm done. And today is a really informal live because I just wanted to answer some questions. So if you have any questions, feel free to put it on the chat and I will do my best to respond. So the question I want to, well, first of all, let me introduce myself for those who do not know me, who may be joining me for the first time. My name is Ifama Odolami. I'm an immigration attorney from the Odolami Law Firm in New Jersey. Our law firm serves clients in all 50 states. We are a nationwide immigration law firm. It doesn't matter where you live, we're here to assist you with your family-based immigration, your humanitarian-based immigration, and whatever questions you have, feel free to call my office, 973-993-1900. Remember, there are a lot of scammers out there. You guys be watchful for those people who are trying to scam you on social media. Make sure you're calling my phone, 973-993-1900. That is the number we have designated and dedicated for people who are calling because they want to book a consultation. When you become a client, you have another number which allows you to reach our staff right away. So say hello and here. So let's go with the question I have. I have questions that I want to answer. I want to give you answers to. Then I want to tell you our latest victory. And I'm going to tell you this story so you guys know that miracles are still happening. Okay, so if you're in a difficult situation, especially with your immigration case, you will want to stay tuned to listen to this story. So this is a question I'm getting all the time. It's about Biden's parole in place. You all know that on, I think it was August 19th, the parole in place by the Biden administration took effect. This is a way for people who came into the United States illegally and who are married to US citizens as of June 17th, 2024, and who have been in the United States for 10 years continuously as of June 17, 2024, and who have no serious criminal history, to be able to stay in the United States without having to file a pardon and leave the United States. So this parole in place also applies to widowers of U.S. citizens, as long as they qualify. Also applies to stepchildren of U.S. citizens, as long as they qualify. So this went into effect August 19th. We're all really excited, and we all said filing applications. And I came on live and told you guys, if you qualify, go ahead and file this application, because we know how this happens. We've been through the DACA era where Republican states would fight this parole in place, and that is exactly what they did. That is exactly what they did. August 26th, a federal judge in Texas temporarily blocked the processing of the Biden parole in place. So what I want to make clear is USCIS cannot make decisions on these applications, but you are asked to continue to put in your application. So if you haven't put in your application and you qualify, hurry up and do it now. Now, does that mean that you're going to get approved? No, it doesn't mean anything, because if the court make a finding that it should be permanently halted, then we might be in for some kind of legal gymnastics for a little while, just like DACA. But the halt does not stop you. The stay does not stop you from putting in your application. And remember, you can only put in this application online. The filing fee is $580. Please do not wait. Go ahead and do it. And while we all wait to see what the federal judge in Texas is going to rule, how he's going to rule ultimately. Okay. So that was the question I wanted to answer, because people keep asking, well, what do we do? Does it mean that it's not going forward? We don't know whether it's going forward or whether it's not going forward, but you can continue to put in your applications, and you're encouraged to do so. And if you came in with a visa that has expired, you do not qualify. Please don't waste your money. If you came in with a visa, F1, J1, B1, B2, whatever visa, and you are now, it has expired, you do not qualify. If it's not expired, you do not qualify. This is only applicable to people who came in without parole, without inspection, without admission. So that's what I wanted to say. So now let me tell you this story about a client of mine who had been in this country for over 30 years. I'm thinking, my math is not that great, but like in the 80s, right? Came in the 80s, right? And I'm not going to give very detailed information because of confidentiality, but I'm going to give you enough information for you to know that miracles are still happening for immigrants. So if you're in a situation where you're feeling very depressed about your immigration situation, you don't know, it might work out, but you need to make the first move to talking to an attorney, maybe even several attorneys, because sometimes it takes one attorney to do something different that can shift your storyline. And that's what happened with this client. He's been here for over 30 years. I did his consultation last year, and he had a huge immigration history. He had been ordered deported. His U.S. citizen wife had filed for him. He had been denied. He had American children, and his case was just not. How do you process having a U.S. citizen spouse for many years, having 4 or 5 adult U.S. citizen children, and yet you cannot get your papers? So it had to do with the manner of his entry, right? And so because of the manner of his entry, and because he had been, ordered deported, his case was so complex. So the first thing we did, because when I talked to him, I said, we're going to have a strategy, because you have a really complicated immigration history. So we're going to start from number 1. Let's see if we can get you out of immigration proceedings. And he had already been ordered deported. He was actually, I think he was actually reporting to ICE every single year for the past, 15 years. So this is somebody who had gone to many lawyers trying to figure out what he could do to get himself regularized. All his family was here, but there was just nothing. So we took it in stages. The first stage, we filed a prosecutorial discretion request asking for his case to be, for them to reopen and terminate the case. And let me tell you something, reopening a case where you were ordered deported in absentia is very, very, very difficult. But we did it. Thanks to God, we did it. So the PD was granted, and now we had the uphill battle of establishing that he could adjust his status. We also had to file a waiver, right? And because there was some issues in the past. So luckily for him, thanks to really, really, really good lawyering, his 601 was approved. His I-485 was approved. We went with him for the interview, and he got his green card after over 30 years. So if you're there worrying about your immigration case, listen to this and know that there is hope. Honestly, this was just, this happens. We've had cases. We have a lot of very complex immigration cases, very complex. And when we start, we review the FOIA, we ask questions, very detailed questions, because sometimes it's the question that someone didn't ask that may have, that if in our client, all the lawyers didn't ask this one very important question, and we did. And because of that, the answer to that question, which nobody thought was a big deal, we were able to get him to adjust his status because we challenged the decisions that had been made over and over again because people were not asking the right questions. And so they didn't know, like I always tell you guys, everybody's like, your situation is different from the next person's situation. So it's always good to get the context. And that's why we do consultations. We want to ask those questions and figure out whether what we see is really what it is, or is there another story that could help you? And that's what we did. So this is thinking outside the box and asking the right questions. And we were able to establish that a conclusion that had been reached about my client for years and years and years, over 30 years, was actually wrong because they didn't ask the right questions, and we did. And so our client got his green card after over 30 years in the United States. Congratulations to him and his family. God bless him and his family. I'm so happy for them that our client can be with his family without fear of deportation, without fear of family separation, and he can come out of the shadows and be and contribute to America meaningfully the way he has been doing all these years. So that's what I wanted to talk about to you guys. I cannot tell you the emotions that we as attorneys and working for our clients feel when we're able to get them the American dream. I can't even imagine how our clients feel. We had a case that our client had been denied the green card over and over again because of an alleged 204C, which we knew was not accurate, but because somebody placed that label on her case like over 20 years ago and it stuck. But we fought it, and we fought it by suing in federal court because the denial that USCIS had made in that case was arbitrary and it was capricious, and we fought it, and her case was approved. And so that's how law works, people. That's why I think being a lawyer is like just a gift. It's a gift from God. It really is, because being able to advocate for somebody, being able to think, being able to make arguments. And the great thing about America is it's a country of laws. You guys, do you know how amazing that is? It's a country of laws. You could be the poorest person on earth, but if you have somebody willing to advocate for you, you could win your case. I mean, of course, like every other country in the world, if you're wealthy, things happen faster, maybe better. But America is one country where, human rights, people have rights. And if you have a lawyer, the lawyers in America are very, they fight the status quo, they challenge the laws, and that's what's happening with this Biden parole in place. The 16 states headed by no other than Texas, of course, are challenging it, but that's an American thing, challenge the laws. Everybody has to get their say, whether we're in support or against. This is a country you have a right to challenge what you don't agree with, come with your arguments and see how it goes, okay? So I also want to talk about special immigrant juvenile status real quick, because I'm getting a lot of young people coming to my office who have missed the deadline to file special immigrant juvenile status. Special immigrant juvenile status is a way for young people to get their green card in the United States. They don't have to leave, but they have to they have to meet the requirements, which means they're unmarried, they're present in the United States, they've been abused, abandoned, or neglected by at least one parent. And in some states, death of a parent is abandonment. And we have to show that the child cannot be reconciled with the abusive or the parent that abandoned them or neglected them. And we also have to show that the child is better off staying in this country than going back to their country. So I tell parents this all the time. If you brought your child in here without documents, you must prioritize that child getting their papers. So now sometimes a parent is able to file a petition where the child is a derivative, right? Which works, but you have to figure out how your child can get their papers legally, because these young people coming here, they didn't bring themselves here. They do what they're supposed to do. A lot of them, they go to school, come out, they cannot work because they don't have a work permit. They're watching their friends, move up in, do whatever they want to do, right? Get the jobs they want to get. They're watching their younger siblings who were born here, right? Be able to accomplish their goals, and they're there stuck, not being able to do anything for themselves because they don't have a work permit, right? Because they're not legal in the United States. So now, is every child going to be helped? No, but there's some children who qualify to file special immigrant juvenile status, or some parents who have a pathway that can give their kids a status, and you have to prioritize these children, okay? I think it's like, they come to my office, they're crying because they're like, but I haven't done anything wrong. I didn't even know I wasn't a citizen until I turned 16 or 17. Why am I being punished? I'm just trying to have a life. So think about prioritizing and looking for legal ways for your children to get their papers, okay? And the one way to do that is to have a consultation with one, maybe several attorneys, to see if anybody is missing something. Like I told you, with this client of mine, for over 30 years, he'd been here talking to lawyers, and same deal. They couldn't get anything for him. And he came to our firm, and like I said, we asked the right questions. So don't give up if an attorney has told you that you have no pathway. Maybe then you didn't have a pathway. Maybe things have changed now, or maybe they didn't know a key information that would have made a difference in your case. Okay, so it's important to keep your ears peeled, follow up with the news, continue to follow the social media channels to figure out what's going. And lastly, talk to an attorney. Please don't talk to notarios or people who are not qualified to give legal advice. As an attorney, I'm required to do continuing legal education. I must continue to register for 24 credits in New York, New Jersey, to keep myself updated, right? So for anyone who goes to somebody who is filling out forms for them, honestly, if they screw up your case, that's on you, And if somebody is filing a petition for you, for heaven's sake, get a copy of whatever they filed for you. Have an understanding of what they're filing for you before they submit it. Because if they submit fraudulent documents on your behalf, you're on the hook. You are on the hook. Okay? So let me answer some questions, and then I will head out. So Glove Master says, hello, attorney, please let us know how approximate the time I-360 approval. What about I-693 submission process based on VAWA? How successful are you dealing with VAWA? So Glove Master, that's a great question, and thank you for the question. As you guys know, VAWA is something that we do a lot of. And knock on wood, we have not been, we've won our cases, knock on wood. So I-360 is taking about 3 to 3.5 years. Some could be less for some, could be more for some. So that's just the average. You can go to the website, USCIS website, to figure out what the processing times are for any of your case types, okay? Now, what about the I-693 submission process based on VAWA? So in the past, maybe 2 years ago, we would do the I-360 first and then wait to get the RFE for the I-693. And the reason was because the I-693, which is a medical form, had an expiration date. So now there's no and because then VAWA was taking 2.5 to 3 years, it made no sense to submit an I-693 with a VAWA because it would likely expire by the time the adjustment of status rolled around. But that has changed now because The I-693, the medical form does not have an expiration. So when we're filing our VAWAs, we're having our clients do their medical exams so that we can submit at the same time. However, if you file your VAWA and you didn't submit an I-693, it's not a big deal. If USCIS approves your VAWA and they're ready to deal with the adjustment of status, they will send you a request for evidence for you to do the I-693. Okay? All right. So Adetola says, I'm a VAWA applicant with a US citizen child. I submitted my application last year, but I'm yet to receive notice of action on my case. I have my receipt number. I'm not in the US. What do I do? So, Adetola Samuel. So if you were not in the US and you filed a VAWA, I'm hoping that the abuse occurred when you were in the US, or you're married to somebody who works in the military and is stationed outside, because for you to file VAWA otherwise, you would have to be in the US. But if the abuse happened while you were in the US and you left, that's fine. So that would mean you're doing it through consular processing. So you have your receipt number, which means they did receive it. You're just going to wait for the process. VAWA is taking a while, so you have to wait for the process, okay? So the second question, as a VAWA applicant, how do I change my address to my relative address in the US since I'm not in the US? I've tried to change it online, but I couldn't. Do I write a cover letter? You really should change your address to the address to your own address. If you have a lawyer, your lawyer also would get communication from the VAWA unit. And you should try the AR11. That's typically what you used to do a change of address. Is that what you tried? Right? All right. So, and if that doesn't work, then send a letter, but if you send a letter, make sure you have a proof of a receipt notice. All right. If you're outside the United States, USCIS should have your address, where you're residing. Okay. Michael Teta says, my US citizen wife wants to file in her own convenience. Yes, she keeps asking me for money. Can I file for VAWA? What if she now wants to file for me after I file for VAWA? So Michael, that's an excellent question. So this is how I would approach this. If your US citizen wife does not want to file for you, then it's a case I would be interested in getting to know more. Why does she not want to file for you? Is she using her US citizen status as a means of control? Is it a way of showing you power? And what else is going on in the relationship? Because a lot of times you can see the dynamics of power and control. And if she's asking you for money, that in itself is not abusive, but is she doing it in an abusive manner? Is she using it as a leverage? Is there financial abuse? So a lot of people think that, if somebody doesn't do A, then it's abuse. But no, you have to show the dynamics of power and control. You have to show it's abuse. So on a case like yours, Michael, I would really want to ask more questions, because I bet you there's more information that would allow me to determine whether VAWA is the right thing for you. Now, if she wants to file for you after you file your VAWA, you have two options. You can continue with your VAWA, which is what I typically tell my clients. The thing about abuse is, some abusers, they have their honeymoon period where, they're all good, and then there's a period where they're torturing you. When you file VAWA, you take the power and control from your abuser, right? Because VAWA does not require you to be separated from your abuser. VAWA does not require you to be divorced from your abuser. In fact, we have a lot of VAWA clients who still live with their abuser. And the good thing is, because VAWA is confidential, the abuser is not going to know about it. All right. So, Michael, I think you'd be best served with having a proper consultation so that we get to understand what else is going on in your relationship and determine if VAWA is the right thing for you. And remember, with VAWA, you also have to prove that it's a bona fide relationship. It's not enough to just be married. You have to show that you married this person because you wanted to have a life with them. You have to show that you didn't marry them only for immigration benefits. You also have to show that you're a person of good moral character. Okay. So, so Noble MP says, hello, I received my approval, my military PIP with a mistake on my date of birth. How do I correct it? So you just need to reach out to USCIS and tell them that they made a mistake. You can do that by sending them a letter. Make sure that letter has a receipt, that you track it so that you can prove that it was sent. Teresa Bradshaw wants to know about videos about working in a church. And this is what I want to tell people, because first of all, you must be in legal status in the United States if you're filing from here, right? Because a lot of people who are out of status are reaching out to me asking for them to get their green card through the church. If you're out of status, the R1 is not working for you. All right. Number two, you have to have a properly designated nonprofit church, religious entity that's willing to file for you. Right. They have to be properly designated. They have to be. You can work 20 hours, as little as 20 hours a week. So those are the two things that I know that you need to know, because a lot of times people are calling my office asking about this requirement, and they're already out of status. Now, if you're abroad, if you're outside the United States, you can as well file the R1 from outside the United States. So if this is something you're interested in, Therese, give my office a call, 973-993-1900, okay? So Adesola Samuel said the abuse occurred outside U.S. My husband is a U.S. citizen. That's why I applied for VAWA. Or should I have applied for another form? So Adesola Samuel, the abuse must have occurred in the United States for you to qualify for VAWA. It's not enough that your husband is a U.S. citizen. And if the abuse happened outside the United States, you have to show that your husband worked maybe with the military and was stationed outside, okay? So I'm not sure, based on what you've just told me, that VAWA would have been the best way for you to go. So let me look at some questions from TikTok. You know, guys, TikTok and Instagram, the problem is it's so tiny, so it's hard for me to read. So somebody says, I had a case dismissed by pretrial intervention, so technically no conviction. What do you think? You know what, Ethereal, I would want to know more about this case, because it depends on what the case is about. You know, in immigration, there's a reason to believe standard, especially with regards to certain offenses, right, such as drugs. So just because there was no conviction it may not put you in the clear. So I'm going to suggest that you talk to an attorney and have a proper analysis of your case. Okay. All right. All right. I'm going to take one more question from from TikTok, and then I will go to Instagram. So somebody says, when should I file the I-134 after the NVC says it's ready? Do you file online or in person? Take it with you in person to your interview, okay? That's for, I'm assuming it's the K visa, right? All right, so let's go to Instagram. Let me answer a couple questions from you guys. So somebody says, my dad is a U.S. citizen with a passport. We're currently in Nigeria. He's sick and needs medical care, but can't travel alone because I don't have a visa. Oh my God, that's really sad. But Oduns, has your father tried to petition you? Because if you're over 21, that's going to take a while. And of course, yes, it's hard to get a visa, but sometimes there's some things that can be done, but it's really difficult, you know, like because it's really difficult to approve if you're coming here and you if you're looking to come here on a B1, B2 to come see your dad. I'm sure you've tried and you might have been denied because USCIS wants to make sure that you're not going to come here and not go back. So you might want to talk to an attorney to see if there's any other pathway for you, okay? Somebody says, I applied for asylum in 2019. How long will it take before my case is approved for a green card? A really long time. And depending on where you are, it could take a really long time because asylum cases are taking quite a while for even the affirmative asylum interview. All right. So I can't tell you how long it's going to take because it really depends on what state you are in. But I can tell you that asylum cases are taking a long time. All right. All right. I'm going to take one more question. So Tevin Explicit says, good day. I have a question. I got a 2-year green card. My spouse is abusive. Do I need them to get my 10-year green card? Tevin, first of all, I'm really sorry that you're going through an abusive relationship. But the good news is that you do not need your spouse to get your 10-year green card. You can apply to remove the conditions on your green card on a waiver of abuse or extreme cruelty. And the other good news is you don't even have to wait for your 2-year green card to reach its expiration. If you're in an abusive relationship right now, you can begin to remove your conditions right now based on abuse. So give us a call. We can assist you with that. This is one of the areas of law, immigration law, that we do a lot of. And I got to say that we're really successful with that. Okay, 973-993-1900. All right, so guys, I got to run because it's 6:26. But I just wanted to answer those questions on Biden's parole in place. For those that qualify, please go ahead and put in your application, even though the federal judge in Texas has temporarily blocked blocked USCIS from making any determinations on the ones that were approved. But go ahead and just submit it. Let's see where this court cases will take us. All right. And for the rest of you, have a great week, and I will be back again. All right. Take care. Bye-bye.